Welcome to week number six. Week number six, Introduction to Criminal Law, Term 1, Spring Quarter, 2018. This is it. This is the final lecture. As you know, next week, your course ends on Tuesday at 11:59 p.m. Central Standard Time. All assignments must be in, and your grades will be finalized by the end of next week. So I'm going to spend some time going over the material and information. So let's start by sharing my screen. Okay, as you can see at the bottom, that today is Friday, May 4th, and it has been in the module since the beginning of the quarter that the week 6 lecture will take place today at 8:30 p.m., which is now, and I am going to go right into our announcements. Defenses to criminal liability is the topic of discussion. You're to read Chapter 10 of a brief introduction to criminal law. I previously sent you copies of the PowerPoints. You should have them. And then you should look at the sections on mental disorder, insanity defense, involuntary intoxication, mistake of fact, mistake of law, self-defense, and then the key terms for practice, mistake of law, mistake of fact, and then take that practice quiz because there will be a, um, a test that takes place at the end of next week. Well, and when I say the end, I'm talking about Tuesday. That'll be due. Your discussion posts for week 6 are both due on Tuesday. Your initial post and reply post are due Tuesday. So you want to make sure you get those done. And then the quiz, which is like your final exam, is due. And it says here, all written assignments are due Tuesday, May 8th. And reminder that term 1 ends 11:59 p.m. Tuesday, May 8th. Then I ask you to take time to complete the end of quarter student evaluations that you received in your email. I appreciate that as well. This is my first go at 5.5 weeks, and this is a pretty good course, though. And then we discussed earlier, start strong, and right now we are hoping that you are finishing strong. Okay, so again, just very quickly, let's take a quick look at the course calendar. And it's got some extra stuff in there, so let me take it out. It's got J250, which is T2. Okay. All right. So now, if you look at this, you'll see that this is where we are. The week of actually, we're at this week. We're here in week 5, and your reply posts for week 5 are due, of course. But for week 6, your reading assignment has been given already, as well as your initial post and reply posts, as I said, are due on the 8th, as well as your written assignment. And then there's a note reminding you that the quarter ends. The quarter officially ends. No assignments can be accepted after 11:59 p.m. Central Standard Time. Okay, so now let's go into Module 6. And again, let's go over the assignments. Your discussion posts, murder for self-defense, and you're going to go through this scenario, and then you're going to submit your initial post, and then examine another student's post for the reply post. So everybody should have some posts in by Tuesday. Everybody has to have them in. Perhaps you can do your initial post earlier and maybe your reply post earlier, the way that you do it. So now regarding the quiz, which is like your final exam, okay? And that's what you have in terms of assignments, okay? So there is no written assignment for week 6. Okay, let's look at the course content. Again, it says here things that we're going to go over in just a few minutes. Your quiz, your discussion posts, and then your live lecture. Okay? So let's start out by talking about mental disorder, also called the insanity defense. And you should be aware of the fact that this defense is hardly ever reliably able to be used as a defense. Many states have different laws, and some have done away with them. These defenses for insanity are raised by the defense to rebut the liability or criminal liability they may have for an act that they committed. And it's known as what we call an affirmative defense, or justifiable defense or excuse defense, one or the other. But affirmative means that, again, it is up to the defense to raise it. So in the mental disorder or insanity defense, as it says here, it says that it may be raised, but most often is unsuccessful. I can tell you that in all the years that I represented people, in many cases, and I had some pretty wild instances, I submitted my clients for tests for a psychiatrist, and none of them came back as insane. Even some offenses that you think might be considered as committed by an insane individual. But the defendants find themselves in situations where these tests that are used. In Illinois, you have to almost be guilty of committing an act without planning, without premeditation, without any attempt to cover up afterwards. And it's almost like, for example, if you commit an act, you have to present as if your state of mind at the time of the offense was such that you were out of touch with reality, not by alcohol or drugs or anything, but that it was an illness that you had. Now, there was a young lady, and I don't say young lady in the sense, but there was a lady that in Illinois recently was declared to have a mental disorder, because what she would do is she would go to the airport and she would get on planes, and she would successfully make it on planes, and she flew as far as some foreign countries. I still don't know how it happened, how she boarded the plane, got on, but anyway, they sent her back. And anyway, she did that a number of times. Then finally there were orders telling her to stay away from the airport. And so in the last instance, when she was finally arrested for that, they set her up for trial, but then they determined that based upon all the circumstances as to how she was operating, that her mental state was not good enough, not only to stand trial, but that she could possibly have a defense that she was mentally insane. Now, uh, states like Idaho, Kansas, Montana, and Utah don't have the insanity defense. It says these four states do not allow for guilty but mentally ill verdicts. In these states, if a defendant is determined not guilty because of mental disease, then you're committed for treatment. Well, that happens in many jurisdictions that if an individual is determined that they are not fit, then did not commit the offense, then they found themselves in that situation. Notice this little quote here. It says that while many people may have heard of the defense insanity, the insanity defense, most people don't realize what happens when this does. Now, if you're found not guilty by reason of insanity, that doesn't mean you get to go home. That doesn't mean you can leave the courtroom. Most of the time, when a jury returns a verdict of not guilty by reason of insanity, you're committed to a mental hospital and treated accordingly. Nevertheless, if a defendant is committed to hospital, he or she could be released back into society if a doctor decides that the defendant is competent and safe to be released. So it's also subject to a judge's approval. So the point of the matter is that just because you raise that defense doesn't mean you get to go home. You're going to end up going in for treatment. Now, there are three types of insanity defenses. The first one is called the Norton Rule, and many courts throughout the country follow that, and it started in England. So under this theory, you can only be found guilty if at the time you committed the offense, you were of the diseased mind that prevented you from recognizing that the act you're doing was wrong, and also called the right-wrong test. For example, a defendant would have to prove that at the time they committed a murder, that they thought that they were stabbing, that when they were stabbing someone, they thought it was with a straw, or at the time the person knew that they were stabbing someone with a knife, but for any reason, as a result of mental condition, there was absolutely nothing wrong with killing the victim. Or, put it another way, the individual might think that they're killing an animal instead of a person. Now, Florida follows the Norton Rule. All people are presumed to be sane, and insanity is, as I said, an affirmative defense raised by the defendant. The defendant had a mental infirmity, disease, or defect, and because the condition didn't know right from wrong, didn't know what they were doing was wrong. That's the Norton Rule, okay? Then there's the Durham Rule. And the Norton Rule, by the way, is the one that's pretty much followed here in our jurisdiction, Illinois. The Durham Rule is only used in one state, and that's known as the product of the mental illness test. This is in New Hampshire. That means that the person acts that the product of a mental disease or defect excused from criminal liability. In the case Durham versus U.S., this was a 1954 case. They criticized. They didn't like the Norton Rule, and in other words, mental illness was more complex than simply right or wrong, and had to be the product. Therefore, the Durham test is more liberal than the Norton and stretches the purely intellectual question of, did the defendant, here's the question, know the difference between right and wrong? That's expressed in the Norton Rule. The last test is the substantial capacity test. This test was adopted by a code and basically removed the absolute recognition in Norton that the defendant didn't know the difference between right and wrong. but rather because of a mental disease or defect, lacked substantial capacity to appreciate the wrongfulness of their act. And state of Wisconsin, using this, says a person is not responsible for criminal conduct if at the time of such conduct, as a result of their mental disease or defect, that the person lacks substantial capacity either to appreciate the wrongfulness of their act or the requirements of the law. And the most important thing is that these are all affirmative defenses, and that it is upon the defendant's burden to present the evidence at the time that they committed the offense, that they were out of touch. So, as I said again, the proof is in the sanity defense is either a mere preponderance or the evidence or clear and convincing. It is not beyond a reasonable doubt. Okay. So the key thing is that psychologists are going to be involved when that person. There are a lot of hearings. It's not all cut and dry. And so in some instances, as I said, the jury will render a decision. Mentally ill defendants often spend the rest of their lives in mental institutions. Okay. Involuntary intoxication is also an affirmative defense, which means it's raised by an individual who involuntarily, maybe this person did not, they had someone slipped them something, a Mickey or something, or they became intoxicated and then claim intoxicated as a defense. Look at the examples from the state of Michigan and Kansas. The state of Michigan, the one I like especially, says under the influence or of impairment by alcoholic or drug defense prohibited, exception. The definition states it is an affirmative defense to a specific intent crime to which the defendant has the burden by preponderance of the evidence to prove that they voluntarily consume a legally obtained and properly used medication and did not know or reasonably should have known, did not know that it would cause them to be intoxicated. Therefore, in Kansas, the fact that a person charged with a crime was in an intoxicated condition and alleged to be a crime is a defense only if the condition was involuntarily produced and rendered such person substantially incapable of knowing or understanding. So the intoxication defense is often applied in criminal cases where the person didn't intend. Or for example, it's not like they didn't know, but that the fact that one was, and I mean not like they didn't know the difference between right and wrong, and the fact is that one was involuntarily intoxicated negates their ability to meet the elements of the crime. So it takes away some elements of the crime that are necessary to convict an individual. It says, talks about the last one here, the one about the spike or the Mickey, where a person is slipped something and they find themselves, and then that situation to use that as a defense as well. Okay, but they did nothing wrong. They just got caught. Someone gave them something. Mistake of fact and mistake of law. Okay, I'm going to go over these pretty fast. Mistake of fact basically explains by its name when someone commits a crime but didn't understand the facts. But, you know, there's a general adage that ignorance of the law is no excuse. And you'll see this as in the state of Missouri says, a person is not relieved of criminal liability for conduct because they engage in such conduct under mistaken belief or fact of law unless such mistake negates the existence of the mental state. Under Missouri law, like other mistake of fact statutes, defense can be claimed if the mistaken action is related to an element of the law in question. It has to be an element of the crime itself. If we look at this example, Lisa, while making a large purchase at a home goods store, including a pushmower in which she puts on the bottom of the cart. The top of her cart is filled with several other items while paying for all her other items. Lisa is distracted by her cell phone and doesn't necessarily pay attention to the clerk to ensure that the items are scanned. Lisa pays the large bill with her debit card and leaves the store. She's then stopped in the parking lot by a loss prevention officer who informs her that she didn't pay for the lawnmower. Well, the officer calls the police and requests that Lisa be charged with theft. Lisa would probably claim that, oh, I'm sorry, I forgot, I didn't realize that, and but the clerk neglected to scan the lawnmower. So that can happen, but once again, she didn't intend on doing it, and that would be the argument. Okay. Mistake of law, on the other hand, is defense that can be claimed when a person violates a law, but they thought their actions were legal. Mistake of law is not the same as ignorance of law, as I said earlier, as people are supposed to know the laws where they live. Mistake of law can be applied in situations where a person relied upon the law but found that the law was unconstitutional, or the person acted in good faith, consistent with the court opinion, but didn't apply it properly, or a person acted upon the advice given by a person responsible for administering the law, for example, a police officer, or a person committed an act contrary to law that has not yet been made public or been published. So the key thing is that the individual is relying upon the situation and circumstances, and it says that mistake of law states that a person's good faith, that conduct doesn't constitute a crime, is an affirmative defense if they acted in a reasonable fashion of a statement contained in a statute, a court case, an administrative order, or interpretation of a public servant, such as a law enforcement officer or someone of that nature. So the key thing is that the individual is seeking advice from proper authorities, but is not entirely correct. Okay. So self-defense. Let's talk about that. Self-defense is commonly used. I used it in a lot of cases. It is, again, an affirmative defense. It says that the individual either use the proper amount of force for the circumstances. For example, if a person pulls out a gun on you, you have a right to use a gun, a knife, or some weapon commensurate with what they do, they pull. Even if it determined later that the weapon that they pulled out was really empty or either a toy, still doesn't matter. The key thing is that if an individual does that you are in fear of losing your life. Now, let's talk about what we overreach. And unlawful interference can include being punched, shoved, kicked, grabbed, strangled, or held against one's will. The amount of force will likely be deemed appropriate if it stops the interference, but doesn't go beyond that. In other words, the unlawful interference is stopped. The force must also stop. So in other words, you can't use a weapon if a person raised their hands to hit you or something like that. Now, we can consider this. If a person is a karate expert or a boxer or something, a professional, and they use their hands in that situation, then that will probably allow you to protect yourself as an ordinary person in a situation where you might not find that you could use a weapon like a gun or a knife or something big. So let's look at this scenario. Let's look at this. And I again will give you in a minute the Illinois statute here. Um, Bob is walking on the sidewalk with Margaret, and they're approached by a man who's drunk and threatens to punch Bob in the face. Bob tries to avoid the conflict and tells the man, just keep walking. The man shoves Bob, draws his fist back. Bob reacts quicker, punches the man in the face, and he falls onto the ground. Bob, upset because the man just tried to assault him, jumps on top of the man and beats him until he becomes unconscious. Margaret pulls Bob off the man, and they wait for police to come. So the question is, was the force initially used by Bob to stop the intoxicated man from hitting him legal and justified? The answer is probably yes. But Bob went further, got on top of him, and going too far, that's when he negated the possibility of self-defense. Illinois law says justifiable use of force, and says that a person is justified in the use of force against another when and to the extent that they reasonably believe that this conduct is necessary to defend themselves or another against an imminent unlawful use of force. However, continuing with the statute, he is justified in the use of force which is intended or likely to cause bodily harm only if they reasonably believe that such force is necessary to prevent imminent death or great bodily harm or the commission of a forcible felony. So it seems that it's pretty clear that Bob's initial force to stop was justified, as it says here. However, Bob committed great bodily harm when he beat the man into unconsciousness. And it's also to note that self-defense to be successfully claimed must be demonstrated that the unlawful inference was imminent. I had one of my first serious cases I had of a young man who was charged with double murder. He had a gun on him. There were two guys that he let into a crap game, and when he opened the door, let them in, he went to lock the door. They went up about 5 or 6 stairs, announced they were robbing the place. Well, he got his gun out, and he was able to shoot them. Now, he shot them, and they hit the ground. Then he went up the stairs and emptied his gun, shooting them in the back. So my defense was self-defense. And the reason why is because of something I discovered from the medical examiner report. The medical examiner report established that the two guys were dead, consistent with the shots that he fired while facing them, and they facing him with their weapons, because there was no debate about whether or not they had weapons, and that at the time when he went up and shot them in the back, they were already dead. Therefore, you couldn't use the shots after the person was dead because they can only die one time. And so I was successful in getting the jury to understand that. The medical examiner admitted it. It was in writing as well. And the cause of death was given of a single shot, consistent with facing the individual as opposed to the shots that were fired in their back. So it's self-defense in a situation like that. So there is you got the jurisdictions that some require retreat, but most don't. That was a ridiculous concept we used to always say as lawyers, that before you can exercise self-defense, you had to establish that you had a way of escape. That was unfair. And so then what happened is that many of the stand your ground statutes that came about, that became famous here in the United States because of the case down in Florida, the Trayvon Martin case, and so a stand your ground claim claims that if the crime, if they were attacked Also, individuals had to be in a place where they were supposed to be at the time. So individuals can't assert stand your ground claim if they committed a crime when they are attacked. Also, people cannot claim self-defense in cases where they are provoked in the attack. In contrast, some states will not permit a self-defense claim in instances where the in-person attack could have avoided using force. So it's a very interesting concept, but the duty to retreat is generally not applicable in most states. Let's talk about the battered women syndrome. Now, this is an affirmative defense that's often raised in situations where a person has been the victim of domestic violence continuously and reach a stage where they they this they've been so abused that they will take steps to kill an individual, an abuser, and the battered woman syndrome is kind of a mental state that evolves from that, or extreme emotional state. And so, anyway, my point of the matter is that it's a case that I think that in as times have come now that we can probably win those more. I think I could probably win a battered women syndrome case in almost any case because I would never do it with a judge. I would do it with a jury. And the point of the matter is that it, oftentimes people who are jurors have either been the victims or either know of people who are victims. Anyway, they're familiar with domestic violence. And domestic violence is pretty much a hot topic now. And so what happens is that I'll just use this example: is that Diane has been physically abused and battered multiple times by her husband Jim for the past 10 years. Each time it took place, Jim's drunk, and when she's battered the worst and even knocked and choked, one night Jim comes home drunk and they begin to argue over his drinking problem. Jim begins to escalate, and Diane, fearful that she will be substantially battered again, shoots Jim. So Diane is probably going to argue that. Now, you should be aware of the fact that cases like that would probably be okay. I have a friend that unfortunately she was the victim of many abuses by her husband, but what she did was she waited until he went to sleep and got a gun and shot him while he was asleep. And that negated her battered women syndrome. The key thing is that what she did was she premeditated and planned instead of leaving, but that resulted in her going to prison. Now, even with those kinds of cases, jurors will tend oftentimes to be sympathetic to the woman, even in a situation where the law actually was violated because of the tenor of domestic violence in this country. So I'm not going to look at this video here. There's a video in here that actually gives its impact on and what happens in battered women syndrome. And the bottom line is that what that individual is placed in over a period of time is they get to the point that enough is enough. And oftentimes the individual is a big person as opposed to a small person who's the victim. And it's oftentimes a male against a female, but now it can be vice versa, or it can be male against male or female against female in the relationships that exist now. But the point of the matter is the key thing is that that person has been the subject of domestic violence for long periods of time. The castle doctrine is another kind of claim, self-defense, where individuals protect the castle. You can protect your home, your business, or car. And what that comes from is that your home is your castle, and therefore you should be able to protect it. Castle doctrines don't require that the person within the dwelling retreat. And so the mere fact that the intrusion took place in the home justifies the use of deadly force. Now, if that person doesn't have a registered weapon, or they unlawfully have a weapon, that doesn't negate the castle doctrine. What that does is triggers maybe some other laws that are involved. Let's use Kentucky, for example. The use of defensive force regarding dwelling, residence, or vehicles. A person is presumed to have held a reasonable fear of serious injury or great bodily harm, and using defensive force as intended or likely to cause death or great bodily harm to another if that person against whom the force was used was in the process of unlawfully and forcibly entering or unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, and the person who used defensive force knew or had reason to believe that the person that the unlawful forcible entry was taking place or had taken place. So the key thing is that within Kentucky, the reasonable fear of imminent peril of death or great bodily harm to a person is presumed at when you're at your home or in those proper places. Therefore, deadly force is justified. It's also important to note that the doctrine states that also have exceptions to prevent the misuse of deadly force. It doesn't apply when, here are some exceptions, when the person against whom the force was used was a lawful resident or had the right to be inside the area. And there is no injunction that prevents them from being present, or the person to be removed as a child or a grandchild within lawful custody of the person against which force is used, or the person using defensive force is engaged in an unlawful activity. The person against whom the force is used is a law enforcement officer. So anyway, you can look at your states, but here's the final thing I'm going to say, as it's written down here, and it kind of sums it up. It's important to note that this deadly force privilege applies only when the dwelling is occupied. It has to be occupied. In other words, if the homeowner is at work and sees a burglary inside his home with a closed circuit surveillance, he cannot drive home and use the castle doctrine. You should call the police then. Okay. So now, the final thing I want to talk about is police officers using deadly force. Now, when I was a law enforcement officer, we were taught very carefully to recognize and appreciate the fact that we can only use the amount of force that's commensurate with the actions of the other individual. For example, we were told that we could use reasonable force to effect the arrest of another person. Sometimes, though, the force used, like hitting a suspect, like hitting the suspect with a baton, taking him to custody, will cause bodily harm. Just so the force is reasonable to make the arrest, the officer is not charged. However, in similar force applied by a citizen with no authority would be considered battery. Anytime, listen to me, anytime a law enforcement officer, police officer uses force, there is a very serious interview or review of those actions. Um, the deadly force is very scrutinized. You know, there are different agencies within the departments, civilian review boards, and so forth. And that unfortunately, in today's time, we're having too many of these excessive force cases. And I'm not going to go into uh, the restraint and use of deadly force. It's used oftentimes. You've had the Eric Garner case of the chokehold. You've had situations like we had here in the Quan McDonald case, where a young man was shot 16 times. Um, so anyway, the key thing is that police officers are held to a standard that you cannot, just because you're a police officer, use force on someone. It must be commensurate with what the individual. Let's say, for example, you have a gun, and that person is far away from you, not within striking range of you, and you have the gun on that person. That person just has the knife in their hand. It could be excessive force to use that gun because of the mere presence of the knife. Unfortunately, that has happened, and and it comes under review. The key thing is this, guys. When you use the force, it must be that you're in imminent fear. Okay, somebody says, "Oh, I'm in fear even if I'm so many feet away or yards away." Not going to do it. It's going to have to be within striking distance or somewhere close to you in terms of that. From a Second Amendment perspective, sometimes the mere presence of a firearm can prevent the use of deadly force. So the point of the matter is when police officers use force, it is important they use it within the law, within the policies and procedures of the department as well. For example, if a police officer makes an unlawful contact with somebody, such as stopping the person on a sidewalk, detaining that person for no legal reason, any force used in conjunction with the unlawful stop would be inappropriate. The use of force among police can also negatively impact the community relations, as it has time and time again, and we're in a tenor right now where that's taking place. That's why many departments now are re-examining the use of excessive force in their agencies. And I'm not going to go over these two clips because the clips will give you some good scenarios about it, okay? So in the end, I want to remind you again to look at the key terms again, and I always point out to you how that works by going to the flashcards, and when you go to the flashcards, it pops up in another window, and it gives used as a defense. A person can only successfully claim intoxication as a defense to criminal liability if the intoxicated or impaired state was involuntarily caused. And what do we call that? Intoxication. Okay? Was involuntarily caused. Next, a test applied to determine if a person was sane at the time he or she committed a crime. To be successful, defendant must demonstrate their mental capacity prevented them from knowing right from wrong. That sounds like the Norton test. It is. And then you go through a defense that can be claimed if the person violated the law, believed that his or her actions were indeed legal mistake of law. So then so you go through each of these. All right, make sure, and it's kind of like a summary of what we have covered. Okay. All right. So now let's go down. Go back down to the bottom. Same thing. Look at this: mistake of law or fact. and it gives some information that's valuable to help you to understand the mistake of a law or a fact. And what it is done here is it gives you for practice, and you know you can go through and you can do the activity, start the activity. You know, Jane has a white cat named Snowball that wears a pink collar and is left outside each day. One day the cat doesn't return. After a few days later, while out looking for the cat, she finds Snowball and brings her home. However, later that day, she realized that the pink collar has a tag with the name Princess. Okay, Jane contacts police, but she fears that she will be arrested for the theft. This is a mistake of fact. Okay, get that out the way. Defer it for right now. Okay, so then we submit it, and it is correct. Okay, so you go through those kinds of scenarios. Then you go back again, and you go to the bottom again. And then there's the practice quiz, and you go through the practice quiz. Like I said, it's not timed, but it is very important because the practice quiz helps you prepare for the actual quiz itself. Okay, and then finally, I give you the PowerPoints that deal with the defenses that we've already talked about, and it outlines them and it explains them and gives you several options and tells you how they were developed and so forth. And affirmative defenses, okay, talked about the mental defenses, intoxication, other, we didn't talk about the XYY, not going to happen too often based upon your chromosome. The premenstrual syndrome generally doesn't apply, and the Twinkie defense, that's an individual like the old defense that they ate White Castle or ate junk food, and the junk food defense caused them to commit the crime. Nope, not gonna fly. And then the other affirmative defenses, and then finally we get to other defenses such as alibi, double jeopardy, where you've been tried in a case. You cannot be tried for the same case twice. Like, for example, very recently there was some argument that O.J. may have admitted that he committed the murders. Well, he's been tried and found not guilty. Double jeopardy would prevent him from being tried again. Then there's speedy trial defenses there. And that's it. So we've come to the end of the quarter, and I wish each of you the best. Please take time to do the final evaluation of the course itself, 5.5 weeks. This is a quick course, and all 5.5 week courses. But I think the content overall was pretty good. I think the resources that were provided, I provided you with some additional resources that normally aren't provided. I went to get the PowerPoint so that it would help you to study in terms of your assignments. Okay, and so the final word that I'm going to have for you that I need is affirmative defense. That's it. Good night.